I will now call the 10:30 docket, and we have one case on the 10:30 docket, State v. Yankey, 126423. I will ask counsel to please enter their appearances.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Gabriel Yankey, and I'm ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, counsel. Counsel, whenever you're ready, you may approach and we'll hear your arguments. Thank you.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Gabriel Yankey. I request 3 minutes for rebuttal.
3 minutes is granted. Thank you, Mr. Hodge.
Chief Justice Rosen, I wonder if I could use a minute of my time at the beginning and ask the court to go on a thought experiment with me.
What experiment?
A thought experiment. And
well, you could try.
I want you to imagine if I go out on the internet and was able to procure an orange jumpsuit and got it, and I stenciled on the back of it Shawnee County Jail. And then tomorrow I put that jumpsuit on about noon and I walk down Kansas Avenue here at lunchtime. What do we imagine might happen? I think people would probably move to the other side of the sidewalk. They might move to the other side of the street. They might run away from me. And I bet it wouldn't be very long before I had an interaction with a law enforcement officer. And I bet it wouldn't be a very pleasant one. Why? Because jailhouse clothing is designed to send a message. It is designed to communicate this person is dangerous and this person belongs in jail. That's its purpose. That's why Judge Pickering in her dissent said, no one looks innocent when they're standing in a jail jumpsuit. And it's why the United States Supreme Court and this court and every court that has ever looked at this issue has said it is destructive on the presumption of innocence to try a person in jailhouse clothing. We stand here because my client was tried an entire trial in jailhouse clothing. And it is our argument that rendered his trial unfair, and therefore he should be granted a new trial.
Counsel, I want to parse through facts of this case with an eye toward who was obligated to do what and when. Okay? Not should have, would have, with hindsight, just who was obligated. What do you think? I want to parse out responsibilities here. With the first conference that occurred, a few days before trial, there was an interaction and discussion about jailhouse clothing, right?
My client said, I would like to not be wearing this jailhouse clothing. Yes.
And that was in response to a question from the court. My question is, during that conference, did the district court commit error? In other words, did the district court not follow through on an obligation it had at that point?
I think not, Your Honor. I don't have a lot of fault with what the judge did necessarily at that point. The judge said, great, you can definitely wear street clothes. You just need to get your friends or family to bring those for you. And I'd like to think that in a lot of circumstances, that's going to solve the problem.
So, in that same meeting, did your client do something that they that he should have been obligated to do at the end here when the judge asked, do you have any other questions, after saying you'll be allowed to wear street clothing? And he says, no, not at this time. I don't have any questions. Was he obligated at that point to tell the court that I don't have any way to get those clothes? In other words, the same thing he said the morning of trial.
So there's two answers. One, he had already told the judge, I don't know how I would get clothes.
That's different as I read it. That is, I don't know how to do this. Doesn't he have an obligation at that point to say, I can't do it? That's a different statement, I think.
So,
and if you don't, that's fine.
Yeah.
It seems to me we're at a different fork in the road.
Yeah. I also think it's possible, even possibly likely, that he went, all right, I'll try that. And he doesn't know that he can't do it at that point. He doesn't have to know it at that point. And so he could have said, I'll try.
So,
And it turns out he can't.
and I understand, when you look at these cases, I mean, there are all kinds of factual scenarios. You know, we have, in some cases outside of Kansas, we have defendants who show up on the day of trial in a jumpsuit and they say, my family tried to get me clothes here, and the jailers wouldn't let my family do that. That's one factual scenario. I want to play with this factual scenario. And I want to know, because the representation on the day of trial is that he never had an opportunity. He didn't have anybody. There wasn't anybody that was going to bring him clothes. So shouldn't he have said something? Not shouldn't, was he obligated? He's representing himself. I think if we had had a lawyer there, we would say that lawyer was obligated to continue the conversation. And I just want to know whether you accept the notion that your client was obligated to say more at that point.
I don't think my client can be obligated to say more than he knows at that point. And all he knows is he wants to wear street clothes.
And we don't have a record about anything else.
We don't have a record on anything else because the judge didn't make any findings about anything else.
Does he have an obligation to make a record, like a lawyer would have, to make a record about a problem going forward?
Under this court's pronouncement in Ward, no. This court's pronouncement in Ward puts the positive obligation, as Judge Pickering pretty clearly noted, on the court here. This court in Ward said that it is an abuse of discretion to allow a person to be brought into a courtroom. That, by the way, that was just talking about a witness. Yeah. But to allow a person to be brought into a courtroom without articulating a justification showing why it's necessary to do so, which seems to me to be putting the burden on the court to make those findings in those situations.
Once they know about it, I still want to focus on this pretrial conference, because I think that implicates what happens the day of trial.
I disagree with that, Your Honor, but
go ahead.
I mean, I accept maybe that he said, I don't know how to get clothes. And she said, well, get your family to get them. And so he said, or friends. And so maybe he said, I'll try. But it turns out it's hard when you're in jail and you're indigent. Maybe he doesn't have anybody. My colleague suggested that it's far-fetched that he couldn't have anybody that could help him. I don't find that far-fetched at all. And so when he is not able to get clothes, what else can he do but the day of trial come in and tell the judge, you know what? I couldn't get clothes, but I'd like to not be in this orange jumpsuit. That's all he could do. And so it is our position, and I think the law and this court's pronouncements point in every way to then it's the judge's job to say, I need to control my own courtroom. And that this court has said the judge has the obligation to say, well, and so this is, I think about the judge here. I'm like, am I mad at the judge for the pretrial conference? I'm really not, because I think she took this day and get friends and family to bring you some. The problem is when he comes in and says, you know what, I don't have any friends and family. And the judge's response is, all right.
Does that create a precedent that permits defendants to essentially always be able to delay the trial?
That's ascribing a lot of motive here.
And I'm not trying to do that
Yeah.
necessarily, but I'm just asking, are the consequences of the rule you're asking us to adopt that on the day of trial, the defendant can always say, I didn't get close?
Yeah. Yes, because at the end of the day, it's our position, and I think this court's position, that the judge has an obligation to control their courtroom. And so if somebody came in and said, I couldn't get close, then yes. Now, to the extent that you say, this is a bad precedent, this might be dangerous in some. I mean, a judge could have said, you know what? Make sure you can get close. I'm gonna call, or we're gonna have a pretrial hearing the day before, or something like that. Make sure you got close. I mean, but even so, the delay here isn't like And this is one of the problems I have with the Court of Appeals decision here is that the Court of Appeals suggests that, well, what, you know, how long, we don't know how long the delay would have been. It would have been, you know, it would have been measurable, borrowing from, I guess, Fourth Amendment jurisprudence, would have been measurable. That's true. But I guess my colleague thinks it's far-fetched that that my client, you know, would not have people to bring in clothes. What I think is far-fetched is that a judge of the District Court of the state of Kansas can't solve this problem in less than half a day, certainly less than a day.
Would you agree that the due process question we have to ask is whether or not this defendant was compelled to appear in jail clothes?
No.
How would you articulate the due process question?
The way that this court articulated it in Ward was this defendant allowed to be tried wearing jail clothes?
But that can't be the question, because allowing a defendant to be tried in jail clothes is not a violation of the Constitution.
Allowing over his objection.
I want to get back to the defendant's obligation here. The trial started on a Tuesday. Did the defendant have any obligation before Tuesday morning to communicate that he wasn't able to get clothes for trial?
There's no showing of any way for him to communicate until he sees the judge.
Well, yes, there is, if you look at the record, because he filed all kinds of things as per se litigant. So he's communicating with the court. So I don't accept that he's unable to get word to the court.
I mean, no, I don't think he has an obligation until the judge said, this is how you do it. And then the next time he sees the judge, he says, I couldn't do it.
But if he wants to claim that there's a trial circumstance that prejudices me, doesn't he have some obligation to avoid that prejudice?
He told the court 6 days before trial, I can't get clothes.
That's not what he told the court 6 days before trial, counsel. We just went through that.
He said, I don't want
He
these.
says, I don't know how to do it. And that's different.
And she tells him,
I can't do
and
it.
she tells him, here's how a way to do it.
And he doesn't say, I can't use that alternative.
Maybe because he doesn't know that at that point.
It doesn't matter. At some point, I'm trying to figure out what he's got an obligation to do. And you said, well, maybe he didn't know. Okay, fine, we don't have a record. So let's pass that day of that pretrial conference. But now we're the day before trial on a Monday, a work day. And wouldn't he have an obligation to communicate? If he could. I guess that we don't have a record, but if he could.
Maybe he was trying to get clothes over the weekend. And it
failed,
wasn't
but
until he saw the judge that I can't get clothes. The question is, what does the judge do at that point, Your Honor? My client doesn't have an obligation to provide himself with a fair trial.
Yeah.
That's what you're saying. He had the obligation to make sure he had a fair trial.
What has to happen next is where we're going to go. But I'm just trying to figure out, this thing is incremental. So had he had a lawyer and had that lawyer known that he wasn't able to get street clothes the day before trial, that lawyer, we would have said that lawyer was obligated to communicate to the court. Under an ineffective assistance counsel or whatever, I just can't believe we wouldn't say that. Let's get to the morning of trial. So now the judge knows. Is the judge required to stop the proceedings, keep the jury waiting until street clothes can be found, or could the court have instructed somebody to go find some clothes, but started the trial? And then at some, and then half a day later or whatever, after they've gone. So I'm trying to figure out whether the second that defendant walks into the room in a jumpsuit is the game over.
Chief Justice, I'm out of time. Can I continue?
Yes.
Thank you. Certainly, I think this court's pronouncement, the best practice would be, to delay it. To say, let's call some people. I bet we can get some clothes in here within a couple hours. Worst case scenario, we go to trial. By the way, it's not like there's one jury sitting and waiting here. This is in Wichita. they've got a lot of jurors that are called for a lot of court. So it's not like there's one jury sitting here at this time that the judge is making a decision. Certainly, Your Honor, we can look at cases that maybe like Hall, where it's an issue of a juror or, there's a glimpse of some limited period of time where a person's in a jumpsuit. And then we're dealing with the harmless error. It's still error, but then you can look at it from a harmless error standpoint. Obviously, none of that happened in this case. He sat through the entire trial in the jumpsuit.
I understand that. And there was a lot of pressure. I mean, this case had lingered for a great deal of time. I mean, I think the crime was in 2019. And so I think it lingered about 4 years or close to 4 years. I think the crime was March of 2019. And this is early in 2022 when the trial happens. So you're willing to, you think it's a matter of degree, I guess, how long the trial could have proceeded, depending on the record and all that, with the defendant in a jumpsuit before we got him closed, as opposed to, I'm just trying to figure out whether once that bullet's out of the gun, it can't be returned, as far as your position.
Yeah, my position would have been, as soon as any juror, potential juror, saw him in a jumpsuit, any juror that ended up serving saw him in a jumpsuit.
And isn't that supported by the record? Because she said, I don't know whether it was at pretrial or whatever, she goes, I'm going to make sure that no juror sees you. I mean, she specifically said that. In your jumpsuit, you're going to be taken to a separate room before the jury comes in. She made a big deal about that and how that was so important to a fair trial.
But she talked about that I'm remembering that more in the context of the shackles and things like that. But so the answer to the question, I mean, I would be here today arguing it was error if anybody, at least any juror that ended up serving, saw my client in a jumpsuit. But I would acknowledge that it might be that that if there is a harmless error, the harmless error analysis is different. And Hall is the example of that case. But I would argue it was error. I would argue it was error as soon as, and this court's pronouncements and Estelle support this proposition.
Kind of a question based on Justice Biles' observation. The crime took place in 2019, something like that. Arrested shortly thereafter. Was he confined that entire time, or do you know?
I don't know standing here, Your Honor.
But
he was certainly confined for a great deal of time.
A great deal.
But by the way, he also asked to get out on bond at that pretrial hearing. And the judge said no. I mean,
he had asked that several times.
Yeah, obviously. And, and it's not surprising the judge doesn't do that.
He was out for a while.
Again, that's why I'm not really, I guess maybe we just disagree. I'm not really focused on that pretrial hearing as much when the judge says, just get your family and friends to bring it. Because if they do that, we don't have a problem. The problem is when the judge sees this guy walk into her courtroom, the courtroom that she's supposed to have control over, and says, well, that apparently didn't solve the problem. Why didn't this solve the problem? And he says, because it turns out I can't get anybody to bring me clothes. And then it is her obligation. I think this court has said it is the judge's obligation to make sure that this client gets a fair trial. That's all we're asking.
The reason I asked,
and it wouldn't have taken that long.
Well, we don't know that either because we don't have a record. The reason I asked that is there are cases where defendant shows up morning of trial, my family wasn't able to do it. The judge says, well, we're going to find some clothes, but we're going ahead with the trial. And we'll make a record later to see, what happened as far as how long it took and that kind of thing. And then they do that. That's not necessarily forbidden from your perspective.
No, I would argue that a court should never do that. A court should never sort of willingly start a process that it knows is unfair.
There's a difference here. They cannot do that.
Yeah. It's sort of, I guess it's an interesting question, Your Honor, about, can a judge do something knowing, I bet this will be found harmless. Can they still do it? I mean, that's kind of what you're asking. I mean, I would argue, no, a judge should never do anything that they know is incorrect to do.
There is case law that says you can do that. And then they measure whether the judge's actions were reasonable based on the record for how long a time it took to get closure. But that's also different from a viewpoint that says it can never happen. I'm just trying to figure out what the rules are
Yeah,
here.
I mean, I don't think this court's pronouncement has suggested this idea that there's some period of time that you could do this without it being error. And so I'm not, that's not something I'm familiar with standing here. And I would argue it's not. I mean, it's error as soon as a juror that ends up serving at least sees that person. I can see a world where it's the harmless error analysis is different, and that's Hall. That really is Hall. And I would argue, in the right case, that that's, of course, it's all hypothetical because he sat through the entire trial in this case.
Let me ask you
Okay.
one, maybe, I don't know if it'll be the final question, but
I thought you'd be tired because it's the last argument of the week.
yeah, right? You think. So I'm starting with the premise that the relevant legal question for the due process claim is compulsion. And I know that you've made some argument about what that may mean, but that's really the inquiry as the United States Supreme Court has framed it, whether or not Mr. Yankey was compelled to appear in civilian clothing. I understand from your argument, you don't see signs of that until the day of trial, where you have the objections like, I just had no contact. Hypothetically, if the district court judge had made some inquiry and made findings that essentially Mr. Yankey sat on his hands and did not make any attempt to get jail clothing, maybe that would certainly undercut an argument for compulsion. But here it seems that the problem that you're highlighting is that we just don't know because we don't have the answer to why, what happened from the pretrial and the 6 days from pretrial to the first day of trial. But that's all leading to the question, but you have the burden of proof, do you not? And how does that weigh, how does that play out in a circumstance where we don't know the answers to what happened in that 6-day period?
So, I mean, you assert that I have the burden of proof. I mean, I have a burden as an appellant. But I think this is more akin to the cases like denial of right to be present or some situations like that where it can happen, particularly like in a forfeiture kind of situation where like by conduct or lack of conduct or different kinds of things like that, you can waive certain rights. But it's not that it's the burden of the court to make findings to support it, which is exactly what this court said in Ward. I'm not asking you to make anything up. I'm asking you to say, Ward, we meant what we said in Ward, which is it is an abuse of discretion for a district court to allow a defendant or anybody to be in a courtroom, but particularly a defendant, to be in a courtroom in jail clothing without an articulated justification of the necessity of that, which to me seems like it's the judge's burden to do that, to make that. And in the absence of that, it's not my client's obligation to provide that record.
Thank you.
I had a question, maybe again, final or not. The Court of Appeals analogizes this to a last minute request for standby counsel and basically says, we have case law that says that even if that request might have been granted had it come earlier, if it's interposed at the very last minute for purposes of delay, the judge is within its discretion to deny the request, move forward. Why is that analogy wrong from your perspective?
It's because they're dealing with different rights.
But, so the Court of Appeals addresses that and basically says, these are both constitutional rights. We should treat them the same. Why is that wrong?
Two reasons. One, because my client waived the right to counsel. There's no question about that. And once you waive it, it's a different thing about getting it back. My client never waived the right to come to court in street clothes. I mean, he asserted it at the pretrial conference and he asserted it again right before trial. So I think that's a difference. Secondly, I think it's an even more fundamental right that we're talking about. The presumption of innocence is like this bedrock principle of the trial.
Creating tiers of rights. I guess that would be the implication of your argument.
Yeah, and simply that this court has said it's part of the district court's obligation to control their
So do you
court.
think it would be okay if this defendant had at the pretrial said, I'm fine appearing in my jail clothes, that's fine with me? And then on the day of trial said, I changed my mind, I want street clothes, then it would be fine?
At that point, he would have waived his right to appear in jail clothes. An interesting question, but I think we can assume that you can waive that right.
I mean, I can't imagine that one of your colleagues wouldn't be up here saying, wait a second, he asserted his right on the day of trial and it doesn't matter what happened before.
Yeah, I certainly, I guess I would come back to Ward and say, in that situation, under Ward, what should a judge do? And should the judge allow that defendant to go to trial in jail clothes? And the answer is yes, if it's necessary. So in the situation you're talking about, is it necessary for him to do that? And I think very rarely would the answer be yes. I don't know about that with the standby counsel. It's part of the answer is I really think there's this conflating of issues here. Yeah, if my client had a lawyer, the lawyer would have done some of these things. You don't need a license to practice law to get some clothes for this guy. It's just not required.
Whose obligation is it? I mean, does the court in that setting have the obligation, to get down to Goodwill and get a pair of pants and a sweater?
If nobody else can get him closed, yes. Because it's the court's obligation to ensure my client gets a fair trial. And I don't think it's that big of an ask in this case. It's just not that big of an ask. Thank you, Your Honor.
Any other questions? Thank you. Mr. Malone.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Briefly, before I forget, I do want to start by trying to maybe clarify something that came up in counsel's argument. There was this discussion about the difference between compelled or allowed. Issue one, which is the question about going to trial in jail clothing. That is, the language is clear. It's whether a defendant is compelled or required. The allowed language comes in respect to issue two about going to trial in clothing without an instruction or some sort of admonition to the jury. So with respect to issue one, it very much is clear that the law says that it's a problem only if they're compelled to do that, because clearly a defendant can choose to go to trial in jail clothing, and that's different. So I just wanted to start with that. Now, going back to the first issue, I think that Justice Biles, the way you walk through this is appropriate, because you have to look at the context in which this came about. At the pretrial hearing, it was the court on its own initiative, without any comments by the defendant. It was the court who first brought this matter up and basically said, hey, do you have other clothing that you want to wear during trial? The defendant replied, I mean, yeah, I would like to. I would like to be not in orange. I just don't know how I could get access to it. And then the court went into this explanation that you could have family and friends do it, and they would drop it off, and that on the morning of trial, the deputies would then allow you to change in that clothing. So I think that sequence is important, because a couple times in the briefing, and perhaps here today, counsel has emphasized the fact that, well, my guy said, I don't know. Well, he said that before he was given the explanation. Then he was told what to do or how he could do it. He never interjected and said that he wouldn't have access to anybody to do that. And then before concluding that status conference, the court again reminded him how he could do it, asked him if he had any questions, and he said no. Now, counsel has argued today, well, maybe he thought that he would be able to get this done, and it wasn't until those intervening few days when he realized that he didn't have the chance, and that's why he didn't say anything until the day of trial. I would argue that the record does not support that, because when you look at what he actually said on the day of trial, again, he didn't bring this up. It was the prosecutor who first pointed out, hey, judge, he's still wearing the jail clothing. He's got these shackles on. So then the court asked him about the shackles and said, do you want those removed? And then that was the first time where he complains about the jail clothing. And when he gives an explanation and the court says, hey, I told you last week how you could have dealt with this. And he says, yeah, I don't have that. I don't have contact with anybody.
Well, why isn't that, what I don't understand is this guy's in jail. He says he has no contact with anyone. He explains that. It just seems to me that would necessitate a further inquiry of how do you want to proceed? I mean, this never happened. It just kind of jumped to, okay, we're going to proceed, rather than some sort of, do you object to proceeding with trial dressed in jailhouse clothing? He was never given any kind of opportunity to explain his objection to proceeding. He just said, I don't want to proceed. He did say that, and that was it. I'm paraphrasing, but that seemed to be it, rather than any kind of judicial inquiry of what did you do? What is your desire to do? He was never asked, you made the observation that, yeah, you can proceed in jailhouse clothing, but that has to be something that you desire to do. He was never asked that.
And I think that's why I think the wording is important, where he says, his explanation for why he doesn't have the street clothing is, I don't have contact with anybody. And that's where
Why isn't that enough?
well, I think that actually works against the defendant, because I think it defies logic to say that I don't have contact with anybody, that he wouldn't have, if that's in fact the case, how would he not have known that 6 days earlier? And that's, counsel has argued today, well, maybe he didn't know that he wouldn't be able to get jail clothing. It's not that he came to court, when the court asked him about it on the day of trial, it's not that he said, yeah, I tried to get it. I had a couple of people who I thought might be able to do it. I couldn't contact them, or they just refused. They said they didn't want to do it. He's just flat out acting like, and maybe it's true, that I don't have contact with anybody. Well, if that is in fact true, then clearly he would have known that 6 days before. And so I think, Your Honor, you're correct. The court certainly could have at that point handled it differently. But the question is whether the way that the court did handle it was an abuse of discretion, because the court does have broad control over their courtroom. And the court doesn't have to do the things that the defendant is suggesting, as far as trying to contact somebody, or going to the lengths of saying that the court itself would ultimately be responsible to go to Goodwill or to go clothing shopping. I think that simply defies logic to say.
Let me interrupt real quick. Okay, so, I'm not sure that I agree with you, and I think it's something that maybe comes with, knowing people in jail that don't have, just based on my life experiences. But let's focus a little bit about what opposing counsel is talking about, which is, he says, I don't have contact with anybody. Okay. And then the judge just ignores him. But our case law, and that's the basis, he's saying that this was an abuse of discretion because there's an error of law. And the error of law is that after he says that, she has to articulate justification explaining why it is necessary for him to appear in jail clothing. And our case law, that goes all the way back to Ward. That's not a new case. It's there. Why didn't the district court abuse its discretion in the sense of an error of law?
And that's where I think we're bleeding into issue 2, where Ward says it's almost always an abuse of discretion to allow him to go to trial in jail clothing without an explanation for why it's necessary or a limiting instruction. So that's issue 2.
No, this is issue 1.
Well, issue 2 is whether he's compelled to go to trial in jail clothing. He was not compelled. The district court is the one who tried.
I have it backwards. Issue 1 is the jail clothing error. Issue 2 is a jury instruction error.
Right. Issue 2 is the jury instruction error with respect to the jail clothing. Issue one,
I'm not going to talk about the jury instruction.
well, that's what you asked me about, because you cited from Ward. Ward is cited in the context of it's almost always an abuse of discretion to allow a defendant to go to trial in jail clothing without explaining why it's necessary or giving an instruction.
It says, it is almost always an abuse of discretion without this articulated justification explaining why it's necessary. And the court does not consider an admonition. That's an and, okay, to the jury. So you've got 1 and 2. And number 1 is you've got to articulate this justification. And once you've done that, then you have to consider whether, now that you've said this justification, then you can consider whether to admonish the jury. This isn't an either or. This is issue 1, abuse of discretion, whether the judge ignored the law.
I think we have to, and this is where the circumstances of the case are the context is so important. And that's why I think it was entirely appropriate for the Court of Appeals majority to emphasize the fact that a lot of this is not only similar to the context of self-representation and changing your mind at the last minute in that context, and how the court has broad discretion then to do something. But it's also key because there's no doubt that the fact that he chose to represent himself is why this happened. If he had an attorney, as your honors have pointed out, there's almost no doubt that he would have had his civilian clothing.
But you're not answering my question. It doesn't matter what caused it. The question is, did the judge abuse its discretion by committing an error of law by failing to articulate justification explaining why it is necessary for the person to appear in jail clothing? It doesn't matter why it happened.
I think my answer is no. I don't think the judge abuses her discretion in the fact that this defendant went to trial in jail clothing, because the fact that the court did try to avoid this situation days in advance. And then on the day of trial, again, the defendant never even brought it to the court's attention.
What do you mean? I mean, the reality is we don't have a record. And, you could say maybe this happened over that 6 days, but you could also say, he asked around to his jailmate, do you have anybody that could get me some clothes? The fact that he says, I don't have contact with people. I mean.
But I'm not the appellant. But I'm not the one who bears the burden of showing that the district court abused its discretion or showing that all of these hypotheticals actually do or do not exist.
But that's not an abuse. The law is clear. Okay. That she doesn't matter. She has to articulate justification. And she didn't. She ignored him, basically. She's okay, bummer. Let's go on.
On the day of trial, she certainly could have done more. I'm not disputing.
Didn't do anything.
She brought it to his attention.
She didn't bring it to his attention. The prosecutor, because the prosecutor knew that this was error.
Because the prosecutor's doing his job, trying to
convince the judge this is going to be a problem.
One thing that I thought of in preparing for this is we all know, when somebody chooses to represent themselves, there's all the factors that the court has to go through. And one of the things it says is, look, you're not educated in the law. And as a result, you might go to trial and inadvertently.
You don't waive your presumption of innocence when you represent yourself.
But you can waive constitutional rights. You might fail to object. For instance, there could be a trial where a self-represented defendant is representing himself and a witness gets up on the stand and testifies about something that is undoubtedly in violation of the defendant's right to remain silent, which is obviously a bedrock foundational constitutional right. If the defendant does not object because they don't know the law, is the judge supposed to jump up and say, I object? We can't have this testimony and it violates the Constitution of our great country. Of course not. When you choose to represent yourself, you create a whole host of problems, and the love factors are not exclusive. So no, you're not going to look at love and see that one of the things that you have to inform the defendant is, oh, by the way, it might also make it more difficult for you to secure civilian clothing. But they are very clearly told that there are all sorts of issues that this creates, and this is why it's not a good idea. So could the district court have, now I will note, and I know it's outside the record in this case, but Mr. Hodgkinson is well aware of it because we argued the other case involving the same defendant on the same day. He had another case where a judge not only sent the clothing to the jail, but then when the defendant
It's
complained.
not this case. It's not this case.
But the record in this case is sufficient to show that he very much, in the words of the Court of Appeals, he was sandbagging. He was trying to do everything
But
possible.
it's not supported by the factual record.
The Court of Appeals found that it
Right,
was.
So the district, I mean, that, they didn't cite anything in the record to say
They
that.
did. They absolutely did. They cited this request. They cited the last minute request for standby counsel. They cited the in trial request for a mistrial. They went through 4 specific things and they said these are all things that happened at the 11th hour. And they very clearly show that this guy was doing everything possible to obstruct and prevent this case from going to trial. There's absolutely support not only in their opinion, but in the record. They didn't just say that and bring it out of clear blue sky. They cited to the record here.
Counsel, I want to go back to the discussion about whether or not the district judge articulated a reason and ask whether or not the district court statement at the time that we had a conference last week. I told you if you wanted to dress out and wear different clothes, have someone bring you clothes. Is that an articulated reason?
I would argue that it is based on referring back to the conference where they had the.
In other words, the reason might be, I gave you every opportunity and you didn't avail yourself of it.
Right. Yeah, I don't
That
think you.
I mean, that's how I kind of read the record, is that whether or not that's a sufficient reason might be a different question, but whether or not there was any articulation, that seems to me to be what the judge articulated.
I would agree with that. And I think that, the judge doesn't always have to articulate it. It doesn't have to mean that if you feel like you've already explained the situation, that you then have to go back and go over it in as much detail.
How do you understand
from a legal-
Justice Stiegel's question when he says every available opportunity? The only thing she said was, oh, usually people go to family and friends. That's not every available opportunity. What is that?
Well, I think that when she then follows up and says, any questions? That gives clearly, I don't even know how to respond to that because every opportunity, there's a universe of opportunities.
And that was my paraphrase or trying to understand. I mean, I have the record in front of me. I
Sure.
have the words the judge said. I'm just trying to understand whether or not that qualifies as an articulated reason. And if it does qualify as an articulated reason, kind of what is the substance?
But it's not just articulated reason, it's justification.
I guess what I would fall back on is that in all of these cases, to respond to the question of does the judge have to move heaven and earth and do everything possible, drive to Goodwill, get on Amazon, go on the street and see if they can find somebody who's the same size, give him his own clothing, whatever. In all of the case law that's cited in these briefs, I am not aware of a single case where it has been held to be reversible error requiring a new trial in this context. Even in these cases where, even if you were to say, okay, yeah, the judge could have done more to try to secure clothing, but
Is that the issue?
it absolutely is the issue. I just don't understand what more. With the jury instruction, the second issue, he has to show not only that the judge did abuse its discretion, but then because it was not, he didn't request a limiting instruction, so that's reviewed for clear error. So he has to not only show that it was an abuse of discretion, but that there is a reasonable probability that the that the verdict would have been different. Not just that it's possible, he has to show that it would have been a different verdict if this instruction had been given. And so that's why even if you were to find, yeah, the judge didn't do everything by the book here. She should have given an instruction. Maybe she could have done more to secure clothing, X, Y, and Z. Again, I think the Court of Appeals spoke to this in its opinion, the majority did, that yes, there are other things that she could have done. She could have tried to delay it for a few hours to see if somebody could get it. She could have called over to the PD's office and said, are you guys, even though you're not representing him, could you help get him some clothing? But as they said, that's not their role. That's not the role here for the appellate court, is to figure out, are there other things they could have done, and would we have done things differently? It's an abuse of discretion standard. This defendant, again, it was the court and the prosecutor who twice tried to make sure that this didn't happen. It was the defendant who never brought it to the court's attention until he was asked about it.
And why doesn't the prosecution bear some responsibility in this when they identify Mr. Yankey as the person in orange? That happened not only during voir dire, but during trial. And even one of the jurors during voir dire said, you should be dressed in something that doesn't look like you're already sentenced. Doesn't the whole tenor of this, the whole purpose of not being dressed in jailhouse attire, is that's what it communicates, that you're guilty by being in jail, you've already been sentenced, and that's, all the cases speak to the prejudice that occurs. And how do we ignore that? Even with voir dire and the state and everyone identifying him, not everyone, but most identifying him by his attire.
Yeah, I think I think my response is that the voir dire pretty sufficiently addressed this. And I think when you look at
what addresses the problem with it.
Well, it addresses the potential concern. And I think what those jurors said, if anything, tends to support a conclusion that the jurors were, if anything, sympathetic to his plight. They felt like it wasn't like they were viewing it and thinking, oh yeah, this makes us think he's guilty. It was, yeah, we kind of feel bad for the guy. We think that he should be able to go to trial in civilian clothing. And I think only one of the jurors who made a remark about it actually served on the jury. And I think that juror's remark was very much in those lines. So I don't read any of the comments to suggest that anybody on the panel, let alone the final jury, was viewing it negatively toward the defendant. I think it was, if anything, they just felt like, yeah, and of course they don't know the background. They don't know why this came about. They don't have any idea what happened at the status conference. I think they kind of felt bad for the guy, if anything. And that's one of the things I think that the Court of Appeals, my only issue with the Court of Appeals opinion is that on the second issue, the jury instruction issue, they just presume error in failing to give the instruction without weighing the pros and cons, which is what Ward tells us. Now, this court might very well, and I would understand if this court were to say, well, we think that weighing the pros and cons, that the instruction should have been given. And that would be perfectly fair for this court to do. But the panel failed to do the analysis that Ward instructed. And the panel failed to do that analysis, even though they recognized, I think in their language, they said, you know, stronger minds than ours might come up with reasons why an instruction shouldn't be appropriate. And one that comes to my mind immediately is maybe the defendant wouldn't want an instruction because he almost wants to play this up for sympathy purposes. So again, my only problem with the opinion is that they do that, and that they cite a statute that talks about what a judge is supposed to do upon request, when in this case, the court was sua sponte bringing the jail clothing issue. So there was no request by the defendant. And then the final issue is that the panel acknowledged that the defendant had not favored the court with the language that he thinks should have been given in a limiting instruction. But then the panel went ahead and supplied that themselves. And I cited a case in which the Court of Appeals basically said, hey, if a defendant is arguing that a limiting instruction should have been given, but they don't tell us even on appeal what it should have been said, that's not our job to craft that. And essentially, it's failing to properly brief the issue.
Can I ask you, going back to issue one, and the articulated justification requirement that was discussed in Ward and by both sides today, that's not a constitutional requirement, right? I mean, how does that tie into issue one, if at all?
Yeah, I think that's a good point. Because that's not, there is no constitutional right to have a judge give an explanation for its ruling. So I think that does tend to carry over more toward just a general, was it an abuse of discretion type of issue, or should the court have said something else? Did the court make the greatest record possible? Admittedly not in this case, but I don't think that then automatically means that it doesn't change the analysis of whether he was actually compelled to stand trial in the jail clothing. So I think that is somewhat separate from the constitutional right. And courts, we all know that courts don't always make the greatest records for their ruling, but that doesn't necessitate, it's not a per se reversal standard because a district court doesn't make the most thorough record possible. So I think that's an important distinction to remember in evaluating the case, is that that's separate from whether the court somehow compelled this man to stand trial in jail clothing. Again, there's separate questions about whether the court could have done more or what it did was a constitutional violation by compelling him. And at some point, and I think the record absolutely reflects, the defendant was making this extraordinarily difficult on a number of fronts. And you can only do so much. I cannot accept the fact that this court would agree with my colleague's position that ultimately, no matter what the defendant is doing to obstruct, that if it comes right down to it, the judge has to get in his car or her car and drive to Goodwill and go on a shopping spree. I just can't. If that were the state of the law, then the defendant would have plenty of cases that he could cite saying, here's convictions that were reversed because the defendant ended up standing trial in jail clothing. But there's none of those cases in the briefs, and I think that's telling.
When we're looking at the trial process unfolding, it's obvious to me that the prosecutor knew it's a woman, right?
I think it was a man in this case.
The prosecutor, it doesn't matter. I'm just trying to use pronouns, but that the prosecutor kind of knew they had a live grenade in the courtroom here because we've got this defendant in jail clothes. And I sort of dismiss the voir dire. I mean, that's kind of an effort to make sure that there's a little bit of a record of what people think about. That's all fine. But I can't figure out why this prosecutor, when asked, talking to witnesses, would say, please point him out to get an identity and tell everybody what kind of clothing he's wearing. And that happened twice. And that really does seem like somebody trying to take advantage of a situation, which is going to factor into any prejudice discussion that we have. So, I mean, that shouldn't have happened, right?
Yeah, I don't know that I would go so far as to say that it was to take advantage. I think he certainly could have phrased it.
I mean, it shouldn't have happened regardless of the motive.
Yeah, I think he could have. Now, on the other hand, I think it's probably difficult when you're a trial attorney and almost always when you read the record, you'll see witnesses refer to the defendant or somebody else in the courtroom by maybe general physical characteristics, but then they'll also, point out the gentleman in the brown suit and the brown tie or whatever. There's almost always, so it's somewhat, I think it's probably just muscle memory to some degree that the prosecutor is used to saying, can you point him out and tell us what he's wearing? Because otherwise you're limited to, okay, it's the guy with brown hair, and there might be multiple people with brown hair in the courtroom. So it was not done artfully, but I don't think that and the other thing I would point out is that the fact that a witness describes him as wearing jail clothing doesn't change the fact. I mean, the jury obviously already saw that anyway. So it's not like having a witness point out.
And that's, that scenario is asking the police officer what happened, and then the police officer starts describing suppressed evidence, and
Right.
This is identify the person and tell the jury what he's wearing.
Right.
And when you've already got this problem, that really does add to the aggravation of the situation.
I guess again, I don't deny that he could have found a different way to ask that question, but I don't think that, again, it doesn't change the fact the jury already saw that he was in jail clothing. So a witness pointing out the obvious, just like if somebody refers to the defendant as the defendant, jury already knows that this is a person who's on trial. They are in fact the defendant. So pointing out that he's the guy wearing orange clothing when they already are sitting there seeing him wearing orange clothing, it just states the obvious. So I don't want to be, I always hesitate to be too critical of the trial attorneys because they're dealing with these situations that are challenging. And I think when you look at the record here in its totality, it was the prosecutor who was trying to do everything that he could. I mean, if he's trying to go above and beyond. Clearly, if the defendant had an attorney, that attorney would have been doing this work on his behalf. But here, the prosecutor could have easily just said nothing at that pretrial hearing or stood by at the start of trial and not reminded the court, hey, notice he's still wearing his jail clothing. So I think the prosecutor was trying to do the best he could with a difficult situation. And ultimately, it's not, the prosecutor doesn't have the final say. It's up to the court and the defendant to figure out this clothing issue. So I know I am well past my time, and I know these cases don't come up a whole lot, and I understand that it's a difficult case to figure out what the appropriate test is and how exactly the court should have handled it. But just to summarize, our position is that I would ask this court not to speculate too much on what the court could have done differently and whether the court should get a 10 out of 10 for its handling of this matter, but it's whether he was compelled to stand trial in jail clothing. And I think the record reflects that he was not, and that he did this because he failed to tell the court that he wouldn't be able to do what the court had advised him to do.
Thank you. Any other questions? Thank you, Mr. Bowman. Mr. Hodgkinson, you reserve 3 minutes.
Your Honor, my client didn't choose to go to trial. And my client didn't choose to be in jail. He asked to not be in jail. He was told no. We keep talking about compelling. I mean, Justice Siegel this idea of compelling him to do it. The idea is, and this is reflected in the majority opinion in Estelle in this case. They really pointed to, even though they don't give relief to Estelle, the idea that this issue that we're talking about only affects poor people, only affects people who can't make bail, because they're the only ones who are in jail and don't have this control over their life anymore. And then it's exacerbated in a case like this when you have a person who we don't have any reason to doubt when he says, you know what, I don't have anybody. And so we're saying, just too bad for you. You don't get a trial where you get the full presumption of innocence. That's what compelled to go to trial in this situation means. He didn't have any choice over this situation. That's why it's unfair. Thank you, Your Honor.
Thank you. Any other questions? Thank you, Mr. Hodgkinson. Court will take this matter under advisement and